The Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel. Welcome to the Employment Roundtable, where we provide you with the perspectives and information you need to make wise employment decisions for your employees and your organizations. I'm your host, Talitha Ebrite, and today we're talking with Holly Cole, Director of the Equal Employment Opportunity Commission in Oklahoma, and my GableGotwals partner, Ellen Adams, about the use of personal pronouns and employee gender. So, Ellen, let's just get started with talking, explaining for our listeners who might not know. Can you explain what personal pronouns are and why we're talking about them on a podcast that relates to employment?
Sure. So I think we talked a little bit in our prior episodes that Title VII provides protections for folks because of sex. And with respect to the Supreme Court's decision in 2020, that has been interpreted to mean sexual orientation and gender identity. So with gender identity being a protected class, if someone chooses to use pronouns like he, him, or she, her, or they, their, those are personal pronouns that a person might ask for others within their workplace to use in reference to them. We as a firm allow attorneys to, in their signature blocks, use whatever personal pronouns they choose. And some folks opt to do that just to, our good colleague and friend, Paula, often gets called Paul, and she would prefer to provide additional clarity that her name is in fact Paula, and there should be no mistake. And she, her, hers are appropriate personal pronouns for Paula to use. And I use personal pronouns in my signature block because I want to create an environment that's more inclusive, so that for individuals who want to use personal pronouns based on gender identity, that they would feel like there's a more welcome environment for them to do that. So that's essentially what personal pronouns are. And it's just important for folks in the workplace to recognize that if someone is expressing their desire for use of personal pronouns, that could become an issue with respect to Title VII and its obligations for employers to prevent hostile work environment claims.
Thanks, Ellen. And I think a related issue is that a lot of times, folks who are transgender or non-binary often adopt names that are not the names that they have, historically gone by. And that issue, and then the related topic of dead naming, which some of our listeners might not know about. Can you explain those issues to us?
Sure. So if an employee wants to transition and they've previously used a legal name and they want to be referred to by a different name, continuing to reference the old name or the name that they have historically used or pronouns that they have no longer requested to be used has been coined dead naming that individual. So not giving credence to their expressed desire to use the pronouns that they've asserted or to use the name that they want to go by is the issue that we're talking about.
Great. Thank you. And now these have become such important issues that they've prompted many employers to update their policies and their employee handbooks. What types of policies have you seen relating to pronouns and preferred names?
Sure. So, to me, it's all about training and educating folks. And if you have an opportunity in a policy to explain that using someone's personal pronouns could create a more respectful workplace, and the opposite, refusing to honor someone's express personal pronouns and refusing to honor their desired name could be seen as offensive and unwelcome by that individual. So again, I think we've talked about in prior episodes, Title VII is the law at issue here. Courts interpret that to not require folks to be civil and to treat everyone with kindness and respect in the workplace. That's not what Title VII requires. But when we're advising employers about best practices to stay out of the EEOC's way, not Holly, and to stay out of court and to not incur legal fees associated with defending against claims or charges, the best way to do that is to have a policy that stops far short of anything that could give rise to a claim. So we encourage employers to have policies that do intend to create a workplace where there is respect for the individual and there is respect for others' stated beliefs and personal preferences. And that extends to names and pronouns. So if you have a policy, you can describe for individuals what that looks like, and name as one of the ways that you could violate a policy is dead naming, and clarify what that means. You can also train folks in the workplace to have a better understanding of what that means.
Thanks so much, Paula. Sorry. Anyway, sorry, Ellen. Apologies.
No, you're fine.
Thank you for that explanation. So now it sounds like policies are often, as you describe them, sort of a means for employers to signal their values and to establish themselves as, places where their employees can be assured of being treated respectfully. And that includes those employees who are on the gender spectrum. But beyond workplace culture, employers do have legal obligations in this space. So, Holly, can you talk to us a little bit about what types of cases the EEOC has seen in relation to pronouns and dead naming, and what guidance the EEOC offers on this issue?
Yes, and thanks, Talitha, for inviting me to talk about this. It's a very timely topic, and in fact, we have seen a lot of activity, people filing charges based on repeated use of the pronoun that they don't want to go by, or dead naming. And so the analysis under Title VII, when we're thinking about harassment based on sexual orientation or identity or transgender status, it's the same as harassment generally, right? So it has to be severe. It has to be really bad, or it has to happen a lot, has to be unwelcome. So it still has to meet that legal standard that we think about. But to Ellen's point, it's really a best practice for employers to say, we're not going to tolerate any of that. We want to be respectful and inclusive in our workplace, and we want to respect individuals and use the names and the pronouns that they want us to use. So, if you have accidental misuse of pronouns or names, that's probably not going to violate Title VII. But if you've got these repeated intentional events, that's probably going to be problematic. In fact, I mentioned in the last episode that the EEOC has filed 4 lawsuits in the first half of 2023, and several of them involve repeated use of the pronoun that the person doesn't want to go by, or dead naming. So it can certainly rise to the level of harassment in the workplace. And, again, to piggyback on something that Ellen said, I think the policies are very important, because you want to set the standard. You want to tell people, here's our expectations of behavior in the workplace. And we don't want it, it can't be sterile. We can't do that. We can't control, but we can certainly create a respectful atmosphere. So along with having those policies, I think it's important to have some education, some awareness raising. Perhaps employers might want to invite a speaker to come in who is a representative of the LGBTQ community or an advocacy group to come in and talk about these issues and demystify some of it, because some of these concepts are really, they're new to many of us. And, we see a lot of people in Hollywood, or musicians who are either recently out or they're transgendered. And so we know them by this name, and they made a movie under this name. Well, now they're this name. And so what do you call that person? What do you call that actor? That musician. So it's it's great to talk about these issues. We shouldn't be squeamish or
Right.
embarrassed to talk about these, because it's important. And just to make sure that we are being respectful, one, and not violating the law, two. So.
Yeah, I think that's really great advice. Holly, our firm actually adopted a program similar to what you're describing a few years ago. And so we've invited folks, not just, from the LGBTQ community, but from other sort of traditionally underrepresented affinity groups.
Good idea.
To just come in and talk to us in small group settings, around a table, sharing a meal, to just talk about their story and talk about, whatever aspect of their identities we're sort of focusing on. Because, a lot of times we think about these issues in a vacuum.
Right.
And sort of in a, more, we don't put specific faces to them of people who we know and who we're going to be in rooms with. And I think when we personalize these issues, that makes it a lot more impactful for us to think about what we can do to be respectful to them. And so I think that's really great advice. And I also think, one of the things that really struck me about what you were talking about was sort of the, repeated, intentional, pervasive nature of the types of, incorrect pronoun usage or dead naming that we sort of are worried about. I think all of us who have someone on the gender spectrum in our lives understand that it can be a process to sort of get our heads around this new way of referring to people. And it's sort of difficult for us to expect perfection from ourselves, let alone, our employees from the beginning, but we want to be approaching it from a position of respect and best efforts. So
exactly.
I think those are really, really helpful perspectives to have. So thank you to both Holly and Ellen for joining us today. I think this is a really helpful discussion. And thank you for listening to another episode of the Employment Roundtable. Please join us next time as we talk about non-compete and non-solicitation agreements. The Employment Roundtable podcast is produced by the GableGotwals Law Firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel.